Let me tell you first about Daniella. So Daniella is an attorney. She's worked at the Innocence Project since October of 2012. She's worked in foreign policy, legislative affairs, and development. She has an undergraduate degree in journalism and political science, and she is an attorney with a human rights certificate. She's going to tell you about the Innocence Project, but for the purposes of our class, my Wrongful Convictions class, I just looked today, and 311 people have been exonerated so far, as of today, by the Innocence Project using DNA evidence to prove their innocence, including 13 who were on death row. So Daniella is going to tell us about the work of this very important organization and what she does there, and maybe she'll even tell us some ways you can help or participate in the important work of this organization. And thank you, Daniella.
All right, so yeah, my name is Daniella Henry. I am a policy analyst at the Innocence Project. I've been working there for a little over a year, and right before that, I just finished law school. So I'm gonna give you kind of a basic overview of the Innocence Project and our work that we do there, and then more specifically, how we use the causes of wrongful conviction for our reform efforts across the country. So over 300 people have been exonerated in the United States, 311. Actually, 18 have been, 18 served time on death row. On average, they've spent 13 years in prison, although some of our exonerees have spent 20, 25. That's pretty normal to see. And collectively, they've served 3,000 years for crimes that they didn't commit. So what we do at the Innocence Project, especially in our policy department, is try and figure out why or how these people could be convicted of crimes that they did not commit. As you can see from this photo, the majority of our clients are minorities. About 70% are people of color, and a huge majority of our exonerees were arrested between the ages of 14 and 22, so they're very, very young when they go in. Let's see. So at the Innocence Project, we solely focus on DNA exonerations. There are plenty of other innocence organizations that do non-DNA cases as well, but we mostly focus, or solely focus on DNA, mostly because every person has a unique DNA profile. And that profile can be matched to crime scenes. So it's really the only way of distinguishing a match. It's really like the only way that you can figure that out. Obviously, not all cases have DNA evidence. So at the Innocence Project, we mostly focus on murders and rapes because that's where we can find tangible DNA evidence that we can use in the cases. So this next slide basically shows the 4 main causes of wrongful conviction, which are eyewitness misidentification, bad forensics, false confessions, and informant or snitch testimony. So first we're going to talk about eyewitness misidentification. This is the leading cause of wrongful convictions. We basically find it in 3/4 of our cases. So police depend really heavily on eyewitness testimony, and it's really faulty. Basically, eyewitnesses get it wrong 35% of the time, but you know, they get it right sometimes. So we can't solely eliminate eyewitness identification, but we kind of try and find ways of reforming that evidence and reforming the ways that police look at that evidence. So most of our reform efforts are trying to train police to take proper precautions when it comes to lineups. And one of the, 2 of the basic reforms that we advocate for is that lineups be properly composed. So a typical lineup has 1 suspect, and then the rest are fillers, which are non-suspect people that are kind of placed in there. And we advocate for having at least 6 people in the lineup, including the suspect, and then that the people should match the description that the witness gave of the perpetrator, as opposed to matching them to the suspect that police have in custody. So this next slide is basically a description that an eyewitness would give to a cop of what a perpetrator looked like in a robbery. Taking into consideration what you just read, who do you think was the perpetrator of the crime? Go ahead. Yeah, exactly. So the problem with this lineup is that one of the descriptions that the witness gave was that the kid had braids. So your eye is automatically going to focus on that person in the left, is it your left? Yeah, corner, because he's the only one that has braids. So you can tell how unfair this lineup is, because your witness is automatically going to assume that that's the person that committed the crime. So this next slide is of Marvin Anderson. He was one of our exonerees. He actually sits on our board currently. He's amazing. And he spent 15 years in prison, 4 years on parole, for a sexual assault that he didn't commit. He was picked out of a lineup, out of a photo lineup, mostly because all of the other photos that were shown in his lineup were black and white, and his was the only one that was color. So it popped out, it stood out to the witness who picked him incorrectly. And this slide basically just says, we find eyewitness misidentification in 75% of our cases. So next I'm going to talk about faulty forensics. Forensics includes anything, basically anything having to do with like fingerprinting, blood testing, hair and fiber analysis, bite marks, ballistics, anything like that is what we describe as forensic sciences. Now, most of the issues that we see in our exonerations are either crime lab analysts that are purposefully altering the results of testing, kind of like, I don't know if you guys heard of the Massachusetts crime lab scandal, where this person basically lied on like thousands of results, and now Massachusetts has to like go back and, all of those people are basically saying we should all be let go because what you based our conviction on was completely faulty. So it's a huge issue in Massachusetts right now. But a lot of the times it's just innocent mistakes that lab analysts do because there aren't a lot of standards that go into a lot of this forensic analysis. So this is what a typical crime lab looks like. It looks nothing like CSI or Law and Order. It's not fancy. Probably looks like what your high school lab looked like. And the reality is that forensic science is not perfect. In 1999, I think 99, maybe 2000, but the NAS, which is the National Academy of Science, came out with this report basically saying that DNA is the only forensic science that has been proven and that has standards. So when people say that, like, a lot of the times you'll see people in court, experts in court, that'll say, there is a 1 out of 25,000 chance that this person's fingerprint is the one that was matched at the scene of the crime. There are no standards for that. It doesn't mean that it's not true, but when experts go into court and say those things, there is nothing to base that on. So I think that's really shocking to people to know, but it's true. So this is an example of a case where forensics or faulty forensics affected a wrongful conviction. This is Jimmy Ray Bromgard, and in his case, the expert in his case basically exaggerated how probative the hair in that case was. Basically, the expert got up and testified that the hair found at the crime was indistinguishable from his hair, and that there was a 1 in 10,000 chance that it came from somebody else. None of that's true. The testimony basically cemented his conviction, and it was found that the expert in the case just made that number up. He had no basis. So we find faulty forensics in more than half of our cases. And we've done analysis of the first 200 cases, and 19% of them involved hair analysis or faulty hair analysis. So a lot of our forensics work is based around providing recommendations to like crime labs or police agencies, and even trying to create task force or commissions that'll create standards more on the federal level. And this is a picture of our co-founder and co-director at the Innocence Project, Barry Scheck. He was actually on The Good Wife last week. I don't know if you guys saw him, but. And this is Brandon Moon, who I actually just got to meet a couple of weeks ago. His case was mostly an eyewitness misidentification, but also faulty forensics. And then George Rodriguez, that was also one of our exonerees. So the third major cause of wrongful conviction is false confessions, which I think for anyone that has some sort of like moral code or inner moral code is really strange to think about. I find it really fascinating that anybody would confess to something they didn't do, but it happens in about a third of our cases. So at the most basic level, most of the time it's because you've been interrogated for like 10, 12, 14, 18 hours and you break. Another interesting fact about, which is very unique to our criminal justice system in the US, is that cops can lie to you. So during a lot of these interrogations, they'll say things like, oh, well, we found this evidence, we know you did it, or you find in like shaken baby cases that they'll pit a husband and a wife against each other and say, well, if you didn't do it, then your wife must have done it. So there are many tactics that are used. But we do see a much greater risk of false confession with younger people. Teenagers are more likely to falsely confess. And then developmentally disabled or people that are mentally ill have a much higher risk. This is an example of one of our exonerees that falsely confessed. Chris was working at a Pizza Hut where a woman was raped and murdered, and they interviewed all of the employees. And they basically told him that if he confessed, that they had something on him, and that if he confessed right now, he wouldn't get the death penalty. So he was scared. He really thought that this was the only way out. Whatever evidence that they had on him was scary enough for him to falsely confess. And it's pretty much what cemented his conviction in the case, and it was false. So as I said before, we find this in about a third of our cases, and in 35% of the false confession cases, the defendant was 18 years or younger. So like the Central Park Five is a great example of that, of teenagers that there were 5 and all falsely confessed. So at the Innocence Project, what we advocate for false confessions is really simple. All you have to do is record the interrogation from beginning to end. And we've actually seen that cops really like that because most of the time they're not doing anything wrong. So this kind of alleviates them from having to go into court and explain what happened during the interrogation, and they have proof that they didn't convince somebody to falsely confess or pressure them into confessing. So I think this is up to date. There are about like 20 states that record interrogations through legislation that passed, but there are like over 800 jurisdictions that do it voluntarily. So it's a much greater number of police agencies that are represented than here. So the next slide is snitch testimony. I guess it's more politically correct to say informant testimony, but we see this in about 1 in 5 of our cases. And these are basically jailhouse informants that provide testimony, maybe in exchange for something, maybe not, and that testimony is used against the defendant. So here's an example of one of our exonerees that was convicted mostly based on informant testimony. So Dennis Fritz's case is really interesting because they didn't have any evidence really against him. The prosecution was actually going to drop the charges until a jailhouse informant came forward and said that Fritz had confessed this murder to him. It turned out years later, when they were doing the DNA testing, that it was actually the informant who had committed the murder. So there's a reason why you would want to be an informant, but there are other reasons. I mean, many times informants are given a better deal, many times they're given money, many times their informant testimony can even lead to their release. So there's a lot of incentive for informants to come forward. So yeah, we see it in about 15% of our cases. So this is a picture of Barry, again, our co-founder, and Vanessa Potkin, who's one of our top attorneys. Unfortunately, I can't remember his name, but this is one of our exonerees. And basically, another huge aspect of our work is kind of dealing with what happens after. A lot of times, especially when these guys go in, or men and women go in, they're really, really young. They are maybe college age. They have never had a job. They go in for 20, 30-year convictions, and family members pass away while they're in. Years go by, and when they're released, they really have to start from scratch. So another area that we work on is compensation. So about half of states have some type of statute that compensates the wrongfully convicted. The federal standard is $50,000 a year, and then $50,000 more for every year spent on death row. The statutes that are on the books in no way compare to that. For example, Utah, I think, gives like $2,500, like a $2,500 education stipend, and that's it. For a lot of states have caps. A lot of states have bars if people confessed or pled out. They're not great statutes. So a lot of what we do is kind of go back and work on reforming the existing statutes and then really push for reform. And we're mostly sticking to trying to reach the federal level. We think that's a good level, but we also advocate for including, healthcare, mental health, job training, education, those types of things as well. So as of today, 40% of the DNA exonerees have not been compensated. And on average, those that have been compensated usually wait about 3 years before they see any money. So it's pretty shocking when you literally leave prison and you get like $40 and a pair of jeans and a bus ticket, and that's it. And you're waiting around for 3 years to even see anything, if that happens. Brandon Moon, the guy that I showed when they were like at a panel, the picture that I showed, he's from Texas, which actually has one of the best statutes, shockingly. And it's because a lot of our exonerees come from there, but they've really tried to perfect the system. But he actually has still not gotten compensation, and he's been waiting 10 years. And his case is interesting because his exoneration happened before in between statutes, so he kind of decided to sue the state instead, and then realized that that was a bar to getting compensation from the statute. And he's still waiting because his civil suit is still going on, so it's been 10 years and he's received nothing. If you just go to innocenceproject.org, you can get all our information. I'll leave my contact info. But yeah, Our work is really great. I feel like coming right out of school, I really enjoy going to a job where I kind of see the fruits of my labor really quickly, which is not something that we all get to do. Only half of our states have compensation statutes on the books. So if you're not in one of those states, you're not going to get compensated unless you sue the state, but they're usually not successful in doing so. So in the states that you're in, where there are compensation statutes, then you will have to work within that statute. But say if you're in Utah, you're going to get, if they accept your application, you're going to get a $2,500 tuition credit, and that's it. That is a good question and a loaded question because there are a lot of factors that go into that. So yes, usually all evidence is categorized and kept within the state. So another one of our reforms is preservation of evidence, because that is a huge issue, especially, even in New York, it is a huge issue because of how things are preserved, if they are even preserved. But there are now preservation statutes that basically require states to keep evidence in cases for as long as the person is in prison, or for as long as the conviction is for, or the time of the conviction is for. But a lot of states don't have those statutes still. Every state has a DNA access law, and a lot of them have preservation within that, but some of them aren't great. The other issue is that a lot of times during the trial stage of cases, the prosecution does not turn over all of the evidence to the defense. So a lot of times they don't even know that the evidence is there. So that's another huge issue, because you're kind of asking as a defendant for something that you don't even know exists. So yeah, but preservation is a huge issue. We have found, and my colleagues that work in the forensics reforms have found that evidence can be preserved for a lot longer, and it doesn't have to be preserved in the way that we thought. So, refrigerating things isn't necessary for a lot of the things that we thought it was, like for blood. There are all this new research coming out that evidence can be preserved for a lot longer, and it doesn't have to be as well preserved for it to be able to pick up DNA. The most common ways of getting DNA is through blood or semen in rape kits, but there's also something called touch DNA, so that you are able to pick up DNA from even things that have been touched, but it's not as probative, but it's mostly blood and semen. Yeah.
I can say that just saliva.
Oh yeah, saliva, yeah. We don't have offices within prisons, and it really is word of mouth. Yeah. And a lot of times we hear from our exonerees that, when we're on 60 Minutes and the TV is on in the prison, that's how they hear about us. So it's really through word of mouth, but we have, in our New York office, we have an intake department of about 8 people, and we have a room probably half the size of this one, just full of letters that they go through. Outside of the compensation statutes, there are a lot of organizations that help either financially. There's an organization that we work with that's kind of like a grant that's given to DNA exonerees, where they get kind of an immediate fund of a couple of $1,000s. There are organizations that give cars to exonerees so they can get to job interviews and stuff like that. We have a social worker on staff for the cases that we deal with, and a lot of the projects across the country have social workers, but it's definitely not enough. There are definitely not enough resources, but there are a lot of organizations that help, at least in the immediate sense. It's very difficult when an inmate writes to us. the first issue is always they have no idea what kind of evidence is in their case. So it becomes an issue of us trying to investigate what went on in the case. So that's stage one. And then once it gets, let's say we realize that, oh, there should be DNA to test here, years go by before prosecutors even decide to give it to us. We've had cases where there was one particular case where the prosecutor refused and either left or died, and the new prosecutor came in and found a box under her desk with the evidence that they were looking for. So that happens. And then another issue is that a lot of times judges, the laws aren't clear enough that they don't know whether they can sanction a motion to agree to test the DNA. So that's another huge issue. That judges don't even know if they can allow that to happen in a lot of states. So yeah, it's a very long process to get DNA testing.